Then my third example is the other type of volume-based rebates, what's called a retroactive rebate. So this is the situation where, again, on this graph, we have the quantity on the horizontal axis that the customer is buying, on the vertical axis, the price that they're paying. And if they buy up to a certain quantity, they pay the price P1. If they buy more than that quantity, then they get a rebate. But they don't just get the rebate on the additional purchases, they get a rebate on all the purchases they've made from this dominant company within the relevant time period, so typically within a period of 1 year. So if they buy more than the relevant quantity, the threshold in that year, then they will pay the discounted price P2 for all their purchases from the dominant firm. And this means that the analysis can, in fact, become very complicated. And the reason it can become very complicated is because the Commission tends to have concerns that dominant firms often have a degree of sales which are captive to the dominant firms, which can't be competed for, which aren't contestable. So in this example, we say that the initial quantity up to C, that's captive to the dominant firm. Effectively, the dominant firm has a monopoly over that quantity. And the only sales which can be contested are the additional sales between C and A being the total quantity that this customer is going to buy. Now, why is it that there might be some sales which are captive? Well, there are many reasons. One reason might be if we have a firm with a very strong brand. It might be that distributors feel that they must stock that brand. So a typical example might be a brand such as Coca-Cola, and the argument might be, well, a supermarket feels they must stock Coca-Cola because there are some customers who are so loyal to Coca-Cola, if that's not stocked in the supermarket, they won't go to that supermarket, they won't buy their bread and other groceries from that supermarket. They'll go to a supermarket that does stock Coca-Cola. So that's one reason there might be some degree of sales which are captive. So it might be that there are some customers who are willing to switch to other brands, but because there are some customers who are very loyal to the brand, there are going to be some sales which are captive to the dominant firm. Another reason why there might be some sales which are captive is if we have the situation where competitors are very small relative to the size of the dominant firm. It might be that competitors are simply too small to supply the entire customer demand. And in that situation, we find that the competitors, they can compete for only a portion of the customer's demand. They simply don't have the capacity to supply everything the customer wants to buy. So suppose we have this situation. We have retroactive rebates. We have customers who are captive to the dominant firm for some level of sales. Then what happens is that the competitor comes along and it says to this customer, well, I'm going to match the dominant firm's rebated price, P2. I'm going to undercut it slightly maybe. Why don't you switch to me and get a better deal? And the customer says, well, the problem is if I switch all of my contestable sales to you, then I'm no longer going to hit my volume threshold for my sales from the dominant firm, and therefore I'm going to lose the discount on the captive sales that I continue to buy from the dominant firm. So because I'm not hitting the volume threshold, I'm going to pay the higher price P1 for the sales that I must still take from the dominant firm, and so I'm going to be worse off by this black rectangle if I switch to you. So what happens is that the competitor has to somehow compensate the customer for the loss of this discount on the captive sales, which means they have to set a price which is actually below the rebated price. So they have to set this lower price P3 such that there's a benefit on the contestable sales. The price is lower than the price that the dominant firm is charging, and that benefit is shown by the red rectangle, and this red rectangle has to be at least as big as the black rectangle. And in that situation, then the customer might be willing to switch. So the problem is that we effectively, in order to entice this customer to switch, the competitor has to offer a price P3 which is below the dominant firm's discounted price. And that makes self-assessment for the dominant firm very complicated, because they might simply look at their own price and say, well, I'm charging this discounted price P2, that's above cost. The European Commission comes along and says, well, actually, we have calculated the effective price your competitors must charge. That's P3. P3 is below price, and please send us 10% of your turnover because you've infringed Article 102. So that's the dilemma for a dominant firm. And the question is, well, how do you calculate P3? And the answer is you can try and calculate it. It's complicated. It can be done. But quite often dominant firms think, well, this is all far too complicated, so I'm just not going to bother to have a retroactive rebate because the competition law risk is too high. Fourth example is a bundled rebate. So this is the situation where you have a firm which is supplying a number of different products and offers a discount to a customer that takes more than one product from the same firm. So an example is a pay television provider who provides a sports channel and a movie channel, and they charge us €15 for the sports channel, €15 for the movie channel, and then they say to their customers, if you take both the sport and the movie channel, we'll charge you €20 per month for the bundle. So effectively, the customer saves €10 a month by taking the bundle from the dominant firm rather than buying these products separately. So suppose we now have a competitor that wants to enter the market, but this competitor hasn't managed to sign up all the rights to all to the relevant football league or other sports program rights. What they do is they have a movie channel but no sports channel. So they're trying to compete to get the customer to switch for the movie channel. So what price can they charge? Well, the customer thinks, well, currently I'm paying €20 a month to get my package from the dominant firm. If I switch my movie channel to the new entrant, I'm still going to have to buy my sports channel from the dominant firm, and that's going to cost me €15 a month. So any price higher than €5, it's not worth switching. So the competitor has to charge a price below €5. So again, this makes life difficult for the dominant firm because it looks at the prices it's charging. It says, well, my €15 a month, that's above cost. But that's not the price the European Commission will look at. The price the European Commission will look at is this price that the competitor has to match, which is only €5. And if that price is below cost, then the Commission may decide that there's an infringement. So that's some of the complications in terms of looking at prices. Having worked out what is the price that we're comparing with costs, we then have to actually work out, well, what's the cost? And this is another complicated subject. So the approach that the Commission takes is a sort of in many ways, it can be seen as a development of the case law on predatory pricing. So the case law on predatory pricing mentions two cost benchmarks, average variable cost and average total cost. So average variable cost, which is referred to in the case law on predatory pricing, AXO and Tetra Pak, this is the cost that vary with each unit of output. And what the Commission does is it says, well, we're actually not going to use that measure. We're going to use a different measure of cost called average avoidable cost, which can be a slightly higher measure of cost. So to explain the difference here, if you imagine an airline running flights, say from London to Dubrovnik, to take an example from recent personal experience, and you think about, well, what are the variable costs of running a plane service from London to Dubrovnik? Well, what are the costs that vary with one additional passenger, one additional unit of output travelling on that plane? Well, difficult to think what those costs are. It's the cost of providing a cup of coffee and a sandwich. Although from personal experience, I can tell you if you fly on the one airline that flies from London to Dubrovnik, they charge you for the coffee and the sandwich. So there's no cost there apart from the cost that they recover. Maybe there's the cost of printing the ticket, although again, they encourage you to print out your ticket at home. So again, there's no cost there. So what are the variable costs of running this plane service? They may be very low. So the Commission, because this cost measure sometimes in some industries doesn't really seem to be very meaningful, they look at a different measure of cost, a different question, which is they say, well, what would be the cost that would be avoided if this airline was to shut down its service from London to Dubrovnik? Well, if it was to shut down that service, then there would be some cost that would be saved. Obviously, the fuel on the plane, that would be saved. Maybe they leased the plane and they could stop leasing the plane, save some costs, maybe save some staff costs. So there are some costs which would be avoided if they didn't provide the service at all, which are not strictly speaking variable costs. They don't vary with each individual passenger travelling on the plane, but they would be avoided if there was no plane service at all. So those are the avoidable costs, and that's the measure that the Commission looks at in place of average variable cost. So although the guidance paper I find rather complicated in terms of how these cost measures would be used, the way I take it is that effectively avoidable costs is now used as the measure that previously would be variable costs in the case law on predation. So effectively, if price is below avoidable costs, there's a very strong presumption that there is going to be an exclusionary effect, that a competitor is going to be excluded from the market, because if a firm can't cover its avoidable costs, then it's going to be better off just shutting up shop and going away. The other cost measure that's mentioned in the case law is average total cost, and the case law says, well, if price is above average total cost, then we can presume that there's going to be no anti-competitive effect, and if price is below average total cost and variable cost, then more needs to be investigated. So what the Commission again has done here is taken a slightly different measure of cost. They've taken long-run average incremental cost. So to explain the difference here, if you have a firm which only produces one product, then its total cost and its incremental cost will be exactly the same. But if you have a firm that produces more than one product or more than one service, there are going to be some costs which are common to those different products or services. And those costs are going to be included in its total costs, but they won't be included in its incremental cost. So again, to take my example of the plane service, the check-in desks at the airport, those desks might be used not just for a service from between London and Dubrovnik, but maybe a service between Dubrovnik and Zagreb. And therefore, those check-in desks, the cost of that is going to be common to those different routes. It's not going to be specific to the London-Dubrovnik route. So those costs, which are common to different services, would not be included as an incremental cost of the service between London and Dubrovnik. So the way that I interpret the guidance paper is effectively, if we have pricing which is above long-run average incremental cost, then generally there's a presumption that there's going to be no exclusionary effect. If price is below average avoidable cost, then there's a strong presumption there is an exclusionary effect. If prices are somewhere in between, then it may be necessary to look at other evidence in order to actually assess the situation. And certainly in terms of when advising a company on its pricing, the measure that we tend to focus on is the long-run average incremental cost, because we want to be able to say to a company, well, your price is above long-run average incremental cost, and therefore there should be no concern about an anti-competitive effect. So I've very quickly given you sort of an overview of some of the complications and issues that need to be looked at. Given the complications, you often get a situation, as I've described, with the retroactive rebates, that a dominant firm looks at this and thinks, well, this is all very complicated, so I don't think I'm going to go down that route. I'm not going to have a bundled rebate or a retroactive rebate. The analysis is too complicated, the risks are too high. The problem is that obviously firms need to balance their competition law risk with their commercial position, in that if they take an approach which means they're 100% certain that there's no infringement of competition law, they're also 100% certain they're going to lose all their customers to their competitors, and that doesn't make commercial sense. So sometimes firms need to balance these risks, and the important thing is to actually balance these risks on an informed basis, to actually understand, well, what are the risks? What do we know about our costs? What do we know about our prices? To what extent can we evaluate these risks? And that will often require a combination of legal, economics and accounting expertise from within the firm and from external advisors. But if you're advising a dominant firm, it's generally a good idea to try and encourage them to actually think about these issues and look at the relevant issues and make an informed decision where they can weigh up the risks. And hopefully that's going to leave them in a better commercial position than simply saying the law is terribly complicated and why don't we just shut up shop and go away. Thank you.